rights for folks with disabilities as well. So that will be more broadly applicable. Those are the laws that are in place all of the time. But we're going to start with these COVID-19 tenancy protections. So before I get into those, I just wanted to tell you a little bit about us and our organization. We are a nonprofit legal aid organization. Our mission is to protect and advance the legal rights of low-income adults and children with mental health disabilities, and empower them to assert those rights in order to maximize autonomy, achieve equity, and secure the resources they need to thrive. We work in Los Angeles County, so a few of my slides here in the COVID presentation are very specific to Los Angeles County and LA City, but we will also discuss some of the protections in place, other parts of California, because I know we have people joining us, not just from Los Angeles. But we are physically located in Los Angeles, in Koreatown specifically. We serve all of LA County, and we provide legal assistance in the areas of public benefits, fair housing, employment barriers, homelessness prevention, special education. We also now do some reentry work. So we serve a lot of different areas of the law. So here are the topics I'm going to cover in this presentation. First, we'll discuss rent increases during COVID-19, what is and is not allowable. Then we'll discuss the local and state eviction protections that are in place during COVID. We'll talk about COVID-19 rental debt and what happens to that. And then finally, we'll talk about the rental assistance program that is in place. So some limitations on rent increases during COVID-19. So on the left here, there are rent increases that are limited. These are in the state of California. So there's actually a portion of the penal code in the state of California that prohibits price gouging during states of emergency. So that prohibits rent increases of more than 10% during a state of emergency. This also includes between tenants. So it's not just a tenant who's maybe renewing their lease. It would be if one tenant moves out, the landlord can't raise the rent by more than 10% for the next tenant who's moving in. And that is in place during the state of emergency. We also have the Tenant Protection Act, and this is in place all of the time. So it's not just due to COVID, this is always in place. It only applies to certain buildings in California. So this applies to apartments that are over 15 years old, single family homes or condos that are owned by corporations, not by private individuals, and duplexes where the owner does not occupy one of the units. So for those units in the state of California, there are no rent increases that are allowed above 5% plus whatever the change is in cost of living for the year. Currently, that prohibits rent increases above about 8%. So basically, if you're having your rent raised, especially if it's more than 8%, and certainly if it's more than 10%, it's worth reaching out to a legal aid organization, to us or someone in your local area to check if that is legal under the current laws. And then here in Los Angeles, we have a couple of other additional rent increase prohibitions, and your areas or cities may have these as well. I'm not sure, but San Francisco may have one. Other cities may have them. So in Los Angeles, there are no rent increases allowed for those units that fall under either the county or the city's rent stabilization ordinances. So the county has its own rent stabilization ordinance and the city has its own, and they both apply to different buildings, which makes things very confusing, but I'll try and explain it as clearly as possible. So in the county of LA, rent stabilized units are buildings with 2 or more units that were built before February 1st, 1995. So until the end of the year, those units in the county of Los Angeles and unincorporated Los Angeles cannot have their rent increased at all. In the city of Los Angeles, their rent stabilization ordinance applies to buildings with 2 or more units built before October 1st, 1978. So for those buildings in the city of LA, there are no rent increases that will be allowed at all. And that actually is going to be until a year after the state of emergency in the city is lifted. So at any point, whenever the mayor says we are not in a state of emergency anymore, 1 year after that date is when rent increases will be allowed again. So I want to talk a little about the city of Los Angeles and the county protections, and then I will discuss some of the other protections throughout the state, but these kind of give you an idea of the basics of the ones that are in other areas as well. So the city of Los Angeles tied the expiration of their protections to the end of the local emergency in the city of LA. So like I said before, whenever the mayor says there is no more protection or there's no more state of emergency, these protections will go away. But for now, there are no fault evictions allowed in the city of Los Angeles. And a no fault eviction is exactly what it sounds like. It's an eviction where the tenant didn't do anything wrong. The tenant isn't at fault. They didn't violate the lease. They didn't commit a crime, nothing like that. It could be that the owner is evicting everyone and getting out of the rental business and selling the building. It could be that the owner wants to move themselves or one of their family members into the unit, and so they're evicting that tenant to do that, or any other reason that is not the fault of the tenant. So those are completely prohibited in the city of Los Angeles. They also prohibit evictions for unauthorized occupants, pets, or for nuisance if those things are due to COVID-19. So the example I like to give is if your mother lost her job because of COVID, and she had to move in with you because she couldn't afford her rent and she's not on your lease, you can't be evicted for her being there because she's there due to COVID. If she brings her dog with her and you're not supposed to have pets, you can't be evicted for having that dog there because it's there due to COVID. And if the dog is barking a bunch and bothering your neighbors, you can't be evicted for the nuisance from that dog because it's all due to COVID-19. LA also still has their prohibition on evictions for non-payment of rent. So people in the city of Los Angeles should not be evicted for not paying their rent if they were financially impacted by COVID-19. The County of Los Angeles has some very similar protections. Theirs expire at the end of the year. Some of their protections are going to phase out earlier. I'm not going to dive into all the different phases right now because it's long and complicated, and I know we're not all from LA. But basically, for right now, this applies to unincorporated Los Angeles, and it also applies to all the cities in LA County. So even if a city has its own protections, like the city of Los Angeles, this acts as a safety net so that if those protections go away tomorrow, then these protections would still be there for the tenants in the city of Los Angeles. Very similar to the city of LA, there are no fault evictions allowed, except that the county does allow for some owner move-ins. So those cases where the owner says, I want to move myself or a family member into the unit. There are restrictions. Right now, they cannot evict anyone for that purpose if the person they're evicting has been financially affected by COVID-19. That protection will unfortunately go away on the 1st of June. They also cannot, if they are moving someone into the apartment, they have to match the state of the person who is currently living there. So if the current tenant is disabled, the person being moved into the unit has to be disabled. If the current tenant is low income, the person being moved into the unit has to be low income. If the person is a senior, the person being moved in has to be a senior. So there are all of these restrictions on when they're allowed to do that. They also have these protections for being evicted for unauthorized occupants, pets, or nuisance if it's due to COVID. And they also are allowing, they are not allowing evictions for tenants who reasonably denied their landlord entry to their home. This will go away June 1st, but for now, if your landlord is wants to get in your home and do some minor repair, and you are concerned about COVID and you say, no, I don't want anyone in my house right now, you cannot be evicted for that. The only reason that they're allowed to evict you is if you didn't let them in where there was an emergency situation. So there was a threat to the health and safety of yourself or your neighbors, or a threat to the property or major property damage. So for example, if your bathtub is overflowing actively, you have to let your landlord into your unit because that would be potentially damage the property, and also potentially could be a hazard to your neighbors and yourself. The County of LA is bringing back protections for non-payment of rent if it was due to COVID-19 as of April 1st. So for rent that becomes due on or after April 1st, tenants will be protected against eviction if they are unable to pay because they've been financially impacted by COVID. So I did want to mention, this isn't very detailed, but I wanted to mention some protections that are in place outside of Los Angeles. So on the left, we have some county protections. Alameda County, you are only allowed to be evicted if there is a health and safety threat, or if your landlord is doing what we call an Ellis Act eviction, which is kind of what I mentioned earlier. The landlord is evicting everyone, selling the building, and getting out of the rental business altogether. So in Alameda County, those are allowed. In San Francisco, they're going to have non-payment protections starting back up on April 1st through the county, which is great. Solano County has protections for non-payment evictions. So you shouldn't be evicted there if you can't pay due to COVID. Sonoma County, very similar to Alameda, they can only evict if you're threatening health and safety or if there's an Ellis Act eviction. Yolo County also has non-payment protections and then also prohibits some no-fault evictions. So those no-fault evictions we discussed with the city and county of LA. Some individual cities also have protections. Fresno has protections against non-payment evictions. Oakland is basically the exact same as Alameda and Sonoma counties. Fremont has protections for non-payment evictions and no-fault evictions. And then Richmond, again, very similar to Sonoma and Alameda, only for health and safety or Ellis Act. And then they also are going to have non-payment protections starting back up in April 1st. So here, now we're getting to some statewide law. So this should apply to everyone who's attending. So throughout the state of California, landlords have to follow certain steps to even get the first step of an eviction through the court. So for those of you who aren't familiar, the way an eviction works is a landlord will first serve you notice. So that could be a 3-day notice, 15-day, 30, 60-day notice. For example, maybe it's a 3-day notice to pay or quit. So that gives you 3 days to pay your rent or they will file an eviction. If you don't pay within that 3 days or do whatever the notice is asking you to do, then the landlord is able to file the eviction in court and say, hey, I gave them notice, they didn't comply. I would like to move forward with an eviction. The first thing a court will do is if they think that the eviction is valid, they will issue a summons to the tenant, which gives the tenant 5 days to answer. Right now, in order to even get the court to issue that summons, that very first step, landlords basically have to show in non-payment eviction cases that they have made a good faith effort to get rental assistance. So they have to state under penalty of perjury that they completed an application and they were denied, or provide a copy of the final decision denying them. Or they can say that they applied for rental assistance, but the tenant didn't cooperate. The landlord is going to have to serve these statements on the tenants when they file the eviction in court. So if you're a tenant and your landlord files an eviction, you should get a copy of all of these statements before you even get the summons that says, you know, oh, my landlord is claiming that I didn't cooperate with rental assistance. What actually happened was I applied and my landlord didn't cooperate. So you'll be able to file that with your answer in the court. It's also really important if you get a summons from the court to make sure you file an answer within that 5 days, because if you don't, your landlord can get a default judgment and win automatically. The 5 days do not include weekends or holidays, just so you know. So if you get this on a Friday, you don't have to count Saturday and Sunday, but just be aware that it's really important to get something in. As I was told when I started this job, the answer can be in crayon. It's just essential that you get something in and then you can amend it later to be more coherent if you need to. So there are also some protections in place if you actually get approved for rental assistance. So anytime before you're locked out of your unit, you can apply for relief as long as your complaint demands, the complaint from the landlord demands COVID-19 rental debt. And then if you have an approved rental assistance application, and whatever you're getting from rental assistance plus whatever you've paid to the landlord will cover your entire debt, you can apply for this relief. So if, say, you've gotten an eviction judgment against you, you're being locked out in 3 days, and the next day day before you're locked out, you get word from the rental assistance program that you have been approved. You can take that to the court, say, hey, stop everything. I've been approved for rental assistance. It's going to cover everything my landlord is asking for. And then the court has to stop it, make sure that you're not locked out of your apartment, and then schedule a hearing for 5 to 10 days out. At that next hearing, they'll determine whether the money has gone to the landlord yet. If it hasn't, they'll schedule another hearing for another 15 days out. If it has, then they dismiss the action. Sometimes you're able to get the money directly from the rental assistance program for your rent. That's if your landlord doesn't cooperate with the program. If it's determined, if one of these hearings pops up and it's been shown that you've gotten the money, but you haven't given it to your landlord yet, just make sure that you let the court know that you are giving it to your landlord soon. You do have 15 days from the time that you're given the money to give it to your landlord. So if you're still within that 15-day period, you can say, I'm still within my 15 days, I will be getting it to them. Just make sure you don't go outside of that 15-day period. So we'll talk more about reasonable accommodations in the next section of my presentation, what they are and how to make them. But generally speaking, they're an exception to a rule to accommodate someone with a disability. And you can make these reasonable accommodation requests of the court and of your landlord at any time in the eviction process, even after an eviction judgment. So this might include more time to file motions or documents if you have a disability that perhaps keeps you need help with filling out documents, you need assistance, you can't do it on your own, and you need more time to do that. You could ask for more time due to that. If you have a physical disability and your landlord wants you out on a certain date and you are thinking that you cannot physically move all of your stuff by that date, you can ask your landlord for more time to move out due to your disability. And sometimes we even are successful in getting eviction actions completely withdrawn as a reasonable accommodation if the eviction is based on something that is due to disability. So for example, some folks have mental health disabilities that cause them to have outbursts or be loud, and they might be being evicted for nuisance. We can sometimes work with landlords to ask for a reasonable accommodation not to evict and to try and find another solution that would mitigate the nuisance in those cases. So I want to talk about small claims court and landlords being able to pursue rental debt in small claims court. So your COVID-19 rental debt that you accumulate, unfortunately, does not just go away. You're able to say, I can't pay due to COVID, but that debt doesn't disappear. You still owe your landlord that money. Hopefully, rental assistance will get out to as many people as possible, and they can get that debt to go away that way. But if you are not able to receive it, your landlord might be able to pursue this rental debt with you in court. They can do civil court or small claims court. I want to talk about small claims because it's very strange and unique. So it's very fast, first off. So your court dates are scheduled within 3 months of filing. The hearings are only 10 to 20 minutes long, and then the decisions arrive within 2 weeks. The biggest quirk about small claims court is there are no lawyers. So you will not be able to have a lawyer, and your landlord will not be able to have a lawyer. However, your landlord might have a lawyer to prepare them to go into this. So we are helping folks prepare for these. A lot of other places, legal aid organizations are helping people to prepare for these claims. I believe LAFLA, which is a legal aid organization in Los Angeles, is starting a whole program to help people prepare for these cases. So please reach out to your local legal aid organization to see if they are willing to help you prep. So you don't have to go into this completely blindsided. You can have your everything prepared. These actions are masked, which means that they won't show up on your public records. So the debt itself, the fact that you owe money to your landlord will still show up on credit reports, but the fact that your landlord took you to court over it will not, which can be really huge when you're trying to find housing. If you need an interpreter in small claims court, absolutely ask for one. And then if you are in LA County, and I'm sure other counties have similar programs, LA County offers free counseling and mediation for landlord-tenant claims. So if you need that service, feel free to look into whether your county offers something similar. So I've talked a lot about rental assistance and how it can protect you. I really recommend everybody go, if you need rental assistance, go to the state of California rental assistance website or call them and get rental assistance. We just got word that they may stop taking applications at the end of March, before it was going to be no expiration date. And obviously, advocates are working really hard to try and extend that and make sure they don't stop taking applications. But just in case, get your applications in. Your immigration status does not affect your eligibility. There are income requirements. You just have to be, below 80% of the area mean income. Um, and you might have a local program as well, but if you go to this website and you're supposed to be applying through a local rental assistance program, it will direct you to where to apply. So we encourage everyone to go here, apply for rental assistance. You can use this for your rental debt, your back rent. This says from April to September, but they are extending it. You can get more money for back rent for months since then because they were so slow rolling it out. You will get 100% of your back rent. Future rent payments are currently, they're not accepting applications for that because they had to prioritize the back rent and they're concerned about running out of money. But theoretically, you could get money for rent that you owe in the future if you know you won't be able to pay. And then the other big thing is you can get money for utilities, utility debt. So say that you have been prioritizing paying rent to stay housed and you have been setting aside your gas bill or your electric bill. This can help you pay that gas bill or electric bill off as well. Landlords and tenants can both apply. If the landlord applies, it's a lot faster and it goes a lot quicker. The money will go directly to them. But if they don't apply, you can get 100% of your arrears and you just have to agree to give the money to the landlord within 15 days. And you can now also use this for a former landlord. So before that wasn't a possibility last year in the program, but now you can use this if you've moved out and you still owe your former landlord money, you can use this money to pay them. A couple of phone numbers here. So the top number is for general questions with the rental assistance application. You just don't understand maybe one or two questions on the application and you need a little help. That would be the top number. If you need assistance in another language, or if you need additional help, you need someone to help you fill out the whole application, that second phone number is the one that you should call. And we will make sure that everyone gets these slides, by the way, so you'll have this information. If you get an eviction defense or an eviction notice, here in Los Angeles, there is a coalition called Stay Housed LA. You can go online or call them and be connected to an eviction defense attorney. I have a couple of other places here. So in San Francisco, there's the Eviction Defense Collaborative, and in San Diego, there's the Legal Aid Society of San Diego. So contact your local legal aid organization, in short, if you get an eviction notice. And that is it for the first presentation. I will stop screen sharing and see if we have any questions that we need to address.
I believe I answered the questions in the chat. So let's see if we have any questions from our Cantonese or Spanish participants.
Yes.
Spanish speaking participants. And I will put a link. I already put a Orange County Legal Aid link in the chat, but I'll put it in again for if somebody's facing threat of eviction in Orange County. We're waiting to see if we have any questions from our Spanish and Cantonese speakers. While we're waiting for that, Kate, there was a question earlier about somebody who has a friend who's living with him because the friend, I believe, lost their job due to COVID, and whether that person would qualify for protections. I believe they were referring to your LA County material earlier, so maybe you could elaborate on that a bit.
I believe so. To my knowledge, there's no limit if it's a family member, but that might be something that I should look into just to double check. But I think that it's, if
it's not limited. It's just if somebody is staying with you due to it's not limited to family. And that's specific to the LA area, right?
Yes.
there may be other, if you live in another area, there may be other protections that apply to you as well. You know, and even if there aren't any COVID specific protections, there may be other ways to maintain that tenancy. So certainly if you're facing notices or problems with the landlord, contact a local legal aid attorney. If you're in LA, contact us, or another, legal aid, or the Stay Housed LA coalition, or you can also contact any local attorney. Oh, let me get those Orange County links. I'm not hearing any questions.
Well, they're also maybe interpreting what we're saying while.
Oh, right.
So not able to ask. So yeah, give them a chance to ask if there are questions and
Okay.
let us know.
We'll give it another second before we move on.
And I know our interpreters are on the other channel, so if you want to message us if there are questions or if there aren't, feel free.
So Yekfi and Neva, this is Pip. Do you have any questions from attendees that you would like? Okay.
Looks like no.
No. Okay. Why don't you
Great.
keep going, Kate? Thank you.
Absolutely. All right. So we might run over a little bit. I know I need to speak more slowly as well to give our interpreters a fair chance to interpret all this exceptionally complicated information. So we might run over a little bit. I will be available to stay beyond 1 o'clock. I recognize some people who are listening might need to go, but just so you know, if we run over, I will stay around for questions. Okay, so let me share this one. Oh my gosh, I had my screen a little off, so I didn't have the right button. Okay. So now we're going to discuss fair housing laws for individuals with disabilities specifically. We focus on fair housing for people with disabilities because that is the population that we work with, but these fair housing laws, a lot of them also apply to other protected categories, but we will discuss reasonable accommodations and other things specifically for people with disabilities. So here in California, we get our fair housing law from a few different sources. There's federal law, which prohibits discrimination based on a limited number of categories. But in California, we actually have a lot of additional protections. So it's good to be a Californian when it comes to fair housing law. We have additional protections for other categories that the federal law does not cover. So on the left in black, those are all of the categories that the federal law covers. And then on the right are the categories that are additionally covered in California. So in addition to protections against discrimination based on race, religion, sex, physical and mental disability, we have prohibitions on discrimination based on age, on source of income, marital status, gender identity and expression, and then these additional protections for immigration status, primary language, and then military or veteran status as well. I want to highlight the source of income discrimination because it is a little bit of a newer law, and we are still encountering a lot of landlords who don't know about this and a lot of tenants who don't know about this. So I want to be very clear that it is illegal in the state of California for landlords to refuse to take Section 8 or other housing subsidies. You might get a housing subsidy from another source. It is illegal for landlords to refuse to take Section 8. Landlords used to be able to say, they'd have signs in their windows or on their websites that said no Section 8. That is no longer legal. They also cannot treat applicants or tenants who have Section 8 or other subsidies any differently from other tenants. So they can't only ask for criminal background checks if you are coming to them with a Section 8 voucher. That has been true since the beginning of 2020. The beginning of this year, there were actually some additional source of income protections that went into effect. So it became illegal for landlords to refuse to accept Section 8. Some landlords were no longer saying no, but what they would do is when they would have a Section 8 applicant, they would refuse to complete the paperwork, the extra paperwork that's required for Section 8, or the unit would maybe fail an inspection from the housing authority, and the landlord would refuse to make the repairs to bring it into compliance with the inspection and with the housing authority's requirements. So they weren't refusing to take Section 8, but they were effectively not accepting Section 8 tenants by refusing to follow through with what they needed to do to get that tenant into the unit. That is illegal now, as well as the beginning of this year. So they have to make any repairs required by the housing authority. They have to complete the paperwork and comply with inspection requirements and any other program requirements for the housing authority. And then one last thing is some landlords will require you to make 2 to 3 times the monthly rent in order to qualify for the apartment. When it comes to Section 8 tenants or other subsidies, you're only paying a portion of the total rent as a Section 8 tenant. So your housing voucher might cover a majority and you might only pay $200 a month. In that case, the landlord can only require you to make 2 to 3 times the amount that you're actually paying. So if you are paying $200 a month, they can only require you to make $400 to $600 a month, not 2 to 3 times the total rent. So that is a very important protection as well. So who has to follow fair housing laws? Basically, it's anyone who touches housing. So private landlords, housing authorities, homeless shelters, condo complexes and HOAs, mortgage lenders, if you own your home, some more temporary living situations. So I mentioned homeless shelters, transitional housing, sober living homes, nursing homes, and more than just on this list. But basically anyone who touches housing has to obey fair housing laws. So since we're talking specifically about fair housing for people with disabilities, we want to define what a disability is under fair housing law. So here in California, a disability is a limitation on a major life activity. So it's any disability that makes a major life activity difficult. Mental, physical, social activities, those are all major life activities. So breathing, walking, eating, learning, working, communicating, all of these are major life activities. And since in California, it's just a limitation, not a substantial limitation, which it is under federal law, but just a limitation. For example, asthma is a disability under California, even if it's not, you don't have such substantial asthma that you have a flare up every time you walk or anything like that. Just any amount of asthma, that is a limitation on breathing, which is a major life activity. So that is a disability for the purposes of fair housing law in California. Is alcoholism or addiction to illegal drugs a disability? For alcoholism, the answer is yes. Both current and past alcoholism are considered disabilities. Past drug addiction is also considered a disability. However, current illegal drug use is not considered a disability. There's no real hard and fast line for what separates past drug use from current drug use. There isn't really a legal precedent for exactly the amount of time, but if you've been in recovery for a couple of months and you've been doing well, we would certainly argue that is past drug use. A time that we encounter using this as a reasonable accommodation is when landlords are looking at criminal records, considering prospective tenants. And perhaps a tenant has a crime on there that is drug related. So we would be able to say that drug use was in the past, it was a disability, and so ask the landlord to not consider that drug conviction when they are considering the tenancy. Or it could be even something sometimes when people are under the influence of drugs, they might steal, or they would they might have a theft conviction on their record. That might be able to be overlooked as well because that was due to your past drug addiction, which is a disability. And then the other thing to bear in mind is that people who are currently using illegal drugs may have an underlying physical or mental health disability that they are self-medicating for with the use of those drugs. And that underlying disability might qualify them for a reasonable accommodation. So I want to talk a little about what disability also includes here in California. So it also includes record or history of having a disability, if you've previously had a disability. It also includes perceived disability, so people who are regarded as having a disability even if they don't actually have one, and family member disability as well. So a child's disability in the household or an elderly family member who lives in the household um, also qualify for these reasonable accommodations. So we have this sort of interactive element here. You can feel free to pop answers in the chat. But we just try and we think this is a nice example to try and work through an example of what qualifies as disability discrimination. So is this housing discrimination? Jamie is a veteran who's applying for an apartment. When the landlord goes to the office to get an application for Jamie, Jamie overhears the landlord say that they don't like to rent to veterans because they have PTSD and they act crazy. Jamie fills out an application for this unit but is denied. Does Jamie have a claim for housing discrimination based on disability? I will look at the chat and see if anyone, I see a big yes from someone. Seeing a couple of yeses. Lots of yeses. Great, that's absolutely correct. Yes, because even if Jamie doesn't actually have PTSD or any other disability, the landlord's statement is evidence that they are discriminating based on the perceived disability. They think that because Jamie is a veteran, Jamie has PTSD and will act crazy. And then, of course, here in California, Jamie would also have a claim for discrimination based on veteran status because they're basing that concept that Jamie has PTSD off of the idea that they were a veteran. So I want to talk a little bit about what we mean when we say fair in fair housing. So generally speaking, when we think of discrimination based on race, color, sexual orientation, family status, we think fair means everyone should be treated the same, which is true. When it comes to folks with mental and physical disabilities, they should be treated the same, except sometimes it's necessary to treat them differently so that they can use and enjoy their housing in the same way. So, for example, it might technically be treating everyone the same if there is a housing complex where all the units are upstairs to make everyone use the stairs. But a person who uses a wheelchair should not be expected to use the stairs like everyone else, even though it's everyone being treated the same. That is not fair. So sometimes exceptions have to be made to treat folks with disabilities in a way that allows them to use and enjoy their housing. So I want to give the interpreters a chance to catch up. I know I'm like seeing there's a lot. Great. Okay. So when is a landlord unlawfully discriminating? So there are a few different forms of discrimination that we see. Some of it is very intentional and blatant. So some landlords will say out loud, I don't rent to people in wheelchairs. We don't want any weirdos here. Or I don't rent to people with A, B, and C, whatever disability. Some landlords will say that. That is very obvious intentional discrimination. But I would say probably more often we see discrimination in the form of denying reasonable accommodations when folks with disabilities ask for them, um, because people with disabilities may need an exception to a certain policy that has a disparate impact on those people. So some policies have more of an effect on people with disabilities than people without disabilities, because they effectively make an opportunity less accessible to people with disabilities. And if someone with that disability asks for an exception to that policy and is denied, that can be disability discrimination. So we'll have some examples here on the next page. So these policies here, do they have a disparate impact on people with disabilities? So, and feel free to shout out which disabilities, by shout out, I mean put in the chat, which disabilities are affected. So a property that requires prospective tenants to apply in person at the office, which is a second floor walk up, does that have a disparate impact on tenants with disabilities? And if so, feel free to say which disabilities might be affected by this. We'll look in the chat. People want to toss out. Yes, mobility, respiratory, heart. Yes, all good answers to that. Mobility, yes. Yeah, I'm seeing a lot of yeses. And yeah, absolutely. Tenants with mobility issues, with heart problems, asthma, but additionally, folks with mental health disabilities that make social interaction daunting. So the requirement that you apply in person could affect folks with social anxiety, for example, and make them less likely to apply for this unit. How about a property with a strict no pets policy? Oh, Susie says no, that doesn't have a disparate impact. See if anyone else has thoughts here. I know it's always awkward to make a group of adults do interactive things, so I appreciate that people are participating. All right, Susie says no. Actually, though, yeah, that does have a disparate impact on folks with disabilities. Oh, yes, we have some other answers. Comfort animal, service animal. That's right. Yeah. So if the landlord does not make exceptions for folks who have service animals or emotional support animals, that policy would have a disparate impact on folks with disabilities. I'm sorry. There is a crow that I feed and he is yelling at me outside right now. So I apologize if there is cawing in the background of my video. So what is a reasonable accommodation? I have talked a lot about reasonable accommodations and have not actually discussed exactly what they are. Oh, Susie pointed out in the chat that assistance animals are not pets, which she is absolutely correct about. So that was a little bit of a trick question in a way. So Susie, you were right. Assistance animals are not pets. So a reasonable accommodation is a change in the rules that helps a person with a disability access housing or housing related services. So we've had some examples already, but like waiver of that no pet rule for service or emotional support animals, though as Susie said, they are not pets, so technically they are not subject to no pet rules. Paying rent later in the month. Sometimes disability checks come the second week of the month, for example. You may need to pay your rent at that time. Maybe you need a reserved parking space, or you need to move to a quieter unit because there's some noise going on that's affecting your mental health disabilities. Maybe your neighbor is like me and is feeding the crows and the cawing is driving you up the wall. and you need to move, that could be an accommodation as well. So what makes an accommodation reasonable? It's reasonable if it's necessary due to the disability. It provides the person with equal access to housing and is not an undue burden, fundamental alteration, or direct threat. So we are going to go over each of those elements in detail. If I can get my screen to go. So first, it has to be necessary due to the disability. So what makes an accommodation necessary? It's necessary if there is a nexus or a connection between the accommodation that's being requested and the limitations of the disability. So there has to be some connection between the disability and what is being asked for as an accommodation. So here's another place where we find examples are useful. A tenant in a large complex has a mental health disability that makes contact with strangers anxiety provoking. The front door entrance of the building is frequently busy. The tenant makes a reasonable accommodation request to use a side door entrance that typically only employees use. So is there a connection there between the disability and what's being asked for? Accepting answers in the chat. Brenda says yes. Susie says yes. Julianne says yes. That's correct. Yeah. So there's a symptom of the tenant's disability that is being exacerbated. Laura says yes. That is being exacerbated by using this front door and interacting with people all the time. And using that side door is going to diminish that anxiety. So there is a clear connection there. So how about if a tenant in a large complex has a mental health disability and wants to use the side gate because the main gate is inconvenient? How do we feel about a connection there? Susie says no nexus. Also no. Seeing the no's. Yeah, not without more information. So on these facts alone, no. But there might be, if you do some more digging, another reason that this is, yeah, Brenda, exactly right. Depends on the disability. So maybe this inconvenience really sets off some other thing for this tenant, and having to deal with this inconvenience every single day is really stacking up and exacerbating a mental health disability for them. So without more information, no, but there might be some more information you could get that could make there be a nexus here. So what about when is an accommodation an undue burden or fundamental alteration for the landlord? An undue burden means that the accommodation is too difficult or too expensive. When we say expensive, it generally has to be extremely expensive to qualify as an undue burden. Obviously, a small landlord, a mom and pop landlord versus a corporate landlord, there are going to be different standards for what is too expensive. But generally speaking, it's going to have to be very expensive for a landlord to argue that it's an undue burden for that reason. But there are other things that might be an undue burden. So, for example, a landlord cannot expose tenants to a fire hazard in order to accommodate the hoarding of another tenant. That's probably also, they would argue, a direct threat. But they would also argue that is an undue burden. The landlord can't be expected to do that. However, in those cases, there might be a reasonable accommodation that could mitigate the danger in the meantime. So if it would take far too long to clear out the entire apartment, we might be able to at least move things away from outlets, away from radiators to reduce the hazard. Maybe make sure there's a path to the door, and then connect the person with services and slowly clean out the apartment. It doesn't have to be an all or nothing in that situation. Fundamental alteration is if the accommodation is going to change the nature of the program. So, for example, a landlord can't be expected to walk or feed your emotional support animal because a landlord is typically not walking and feeding their tenants' pets, even though emotional support animals are not pets. Um, Unless you have an amazing landlord who does this for all of their tenants, you're not going to be able to expect your landlord to do this. It's just not part of the typical service that is provided by the landlord. And then direct threat, I touched on it a little, but accommodations can't be a direct threat to the health and safety of others or result in substantial physical damage to the property. So to go back to the hoarding example, maybe a tenant has a bunch of items on their balcony and the landlord is concerned that that balcony is going to give way because of the weight. That could be a threat to health and safety of others, right? If that balcony collapses, it could be dangerous to people, but also would result in substantial physical damage to the property. However, again, landlords have to make these individualized assessments. They can't just say that definitely that's going to make the balcony collapse. So they would have to look at the nature of the risk of injury, how long it lasts, how severe the injury would be, the probability that it'll actually occur. Is this a rickety wooden balcony or is it a stronger metal balcony? How likely is it that it's actually going to give out? And then whether any reasonable accommodations can significantly reduce the threat. So once again, can we move a couple of items, maybe a couple of the heavier items off of that balcony? Is there anything else that can be done to reduce that risk? So how to request a reasonable accommodation? The first step is to request it, which I know sounds very basic, but that is the first step. This request can come from the person with the disability directly or from their representative. So a family member can make a request, a social worker. We as attorneys make these requests for people all the time. And it can be made at any time during tenancy. So while you're applying, while you're living there, or even if you've been evicted or during eviction. Best practices. So we always recommend that it be in writing. It's not required. You can make a verbal reasonable accommodation request, but we're lawyers and we like to have a written record. So we always recommend you have it in writing. Email or text is perfectly fine. Just make sure you keep a copy of the request and when you submitted it to the landlord. In your request, be sure to indicate that you have a disability, but you do not need to tell them what that disability is specifically. You don't have to include diagnoses. Then be sure that you explain the connection between your disability and the accommodation you're asking for. That can sometimes be trickier without revealing what your disability is, and you are free to reveal your disability diagnosis if you want to, but you do not have to. Usually there's a way to talk around it. So you can say, I have a disability that makes contact with strangers anxiety provoking, and I would like to use the side door. You're not saying I've been diagnosed with social anxiety, but you're explaining the disability. And then we also recommend that you use the words reasonable accommodation. That's also not required by the law, but it can help because a lot of landlords recognize that language and understand that it comes with certain obligations for them. So step 2 is then your landlord has to interact with you and try and find a solution. So your housing provider can't just say no. They have to engage you in a dialogue. And there are a couple of things that they're allowed to ask for. So if the disability isn't obvious or they don't previously know about it, they can ask for verification that you have the disability. They wouldn't be able to do this if you're asking for a ramp and you're in a wheelchair. That is not going to be something they can ask that's obvious. And they also wouldn't be able to do it if you've previously asked for a reasonable accommodation, say due to a mental health disability. So they already know. And now you're asking for another accommodation based on that same disability. They already know about that disability. They can't ask for you to verify that disability again. But if they don't already know and it's not obvious, they can ask for verification that this disability exists. Then if they say, all right, I understand that you have the disability, but I don't understand how this accommodation you're asking for connects to the disability, they can ask for verification of your disability related need for the accommodation. So ask for maybe a mental health provider could provide a letter saying, this person has this disability. I can verify that this solution would mitigate that disability. And again, the landlord can't ask for medical records or your diagnosis or anything like that. And then if after all of that, the landlord says, I don't think this is reasonable, I don't see the connection, it's not a reasonable accommodation, then they have to still invite discussion about alternative accommodations. So if there's something else that they can do or that can be done in order to accommodate this person, maybe there are other steps that can be taken. So since they're allowed to ask for verification of disability or the connection between the disability and the accommodation, who can provide that verification? It's actually pretty broad. And so HUD this is a statement from HUD. And also there are similar rules or statements here in California, but for the local laws, that basically say that depending on the circumstances, it could be verification of disability could be even provided by the person themselves. They would say, look, I have this disability. I'm verifying to you that this disability exists. But otherwise, doctors, medical professionals, mental health providers, those are the gold standard. If you can get verification from those people, that's the best. But you could also go to a non-medical service agency, a peer support group, maybe someone in your church or a church group or a pastor, any reliable third party who's in a position to know about the disability can verify the disability. How many reasonable accommodations can you ask for? As many as you need. There's no limit. So if you need 5 reasonable accommodations, you ask for 5. If you need more than that, you ask for as many as you need. And these are just some more examples. Again, we will send you these slides and we will make them available in Spanish as well. Unfortunately, I don't believe we have a Cantonese interpretation, but in the interest of time, I'm going to skip giving further examples right now. So this kind of goes back to the direct threat, but making decisions based on actual behavior is different from responding to stereotypes. So landlords have to make decisions based on a tenant's actual history as a tenant, etc., not just on a stereotype about how someone with a certain disability might behave. So a landlord can't say, oh, say your landlord finds out you have a diagnosis of schizophrenia, and they say, well, I'm going to move you to another unit, or I'm not going to rent to you because people with schizophrenia are violent. A, that's very incorrect, and B, that is illegal, that is discriminatory, because they're basing that on a stereotype, not on your behavior as a tenant. And they have to apply all of these standards to this equally to all applicants. So they can't, as I said, just ask certain people for their history of eviction or their credit history or their criminal history. They have to ask all of their prospective tenants for that information. Briefly, reasonable modification, that is like a physical change to a building. So a ramp for a wheelchair, grab bars in a shower. Usually tenants are going to have to pay for those to install them, unless the landlord gets certain federal funding. Sometimes they have to pay for it. But generally you'll have to pay, and then also pay to remove that if it's something that might interfere with the next tenant's use. If you do install these modifications yourself, just make sure that they're installed correctly and compliant with codes, because otherwise you can get into trouble. Can a landlord talk about your accommodations with other tenants? No. Application, tenant, and guest information about disabilities is completely confidential. Landlords are not allowed to share that with anyone else. Sometimes we see this when landlords, for example, make an exception to no pets policy and you have a service dog or an emotional support dog, and other tenants are giving the landlord trouble and saying, well, why can't I have a dog? A landlord might ask if they can disclose that it's a reasonable accommodation, and you can give them permission to do that, but you are not obligated to in any way. Finally, here's some information on where to file fair housing complaints if you believe you've been a victim of fair housing discrimination. The HUD is where you will go if your landlord is federally funded in any way, including if you get any kind of subsidy like Section 8. If it's a private landlord who doesn't get federal funding, you can complain to the California Department of Fair Employment and Housing. And then we have a list of some other fair housing resources here as well. And finally, this is our information. If you're in the Los Angeles County area and you would like to call us, please feel free, if you have a legal issue that we might be able to help you with, to give us a call, and we would be happy to help you as well. And once again, we will send out these slides so you have all of this information after the presentation. And that is it. We made it a little over time.
No, thank you so much, Kate and Naomi, for being so vigilant with the chat and the Q&A, but it was a wonderful presentation. And to our wonderful interpreters, Yikfai and Neva, thank you. So much information. We will be sending out your slides, the slides to everybody after this. And of course, it was recorded, so it'll be archived on our Family Voices of California website. But thank you very, very much for this really important information. I have so many questions for you, but okay, we'll leave that one. Thank you. Bye-bye, everybody. Have a lovely rest of the day. Goodbye.
Yeah, and feel free to email me with questions, Pip.
Thank you. I will.
Actually, before we go, let me just
Yes.
put the link in the chat really quickly, so folks can fill out the survey if we have another minute or two. Just because we found that it's kind of easiest to get folks right off the bat. Hopefully you have another minute or two to stay in the chat if folks need to leave, and I'm still answering questions.
Thanks, Naomi.
Thank you so
Okay.
much. If you have 2 minutes to fill out the link, that would be really helpful for us. It's just
and we will send it out with the email as well, and maybe hopefully we can send out the Spanish version of the survey also with the.
Yes, you just send it to me. Thank you all. Bye-bye.
Yeah, thank you.